I stand here in opposition to House Joint Resolution 142. D.C. passed a law last summer decoupling from certain tax provisions of the One Big Beautiful Bill Act. This decision was a targeted and time-limited move instituted for 225 days to evaluate revenue impacts and determine which changes could be incorporated in a fiscally responsible manner. D.C.'s decoupling also does not alter or eliminate any federal tax benefits enacted by Congress. Their law applies only to district taxes, and it's not an action solely taken by D.C. In fact, at least 13 states have taken similar steps, and roughly 20 states require legislative review before implementation rather than automatically adopting tax code changes. And while some states decoupled entirely for 2025, D.C. only decoupled from 13 of the 84 tax provisions, with the possibility that D.C. could still implement some of what they decoupled from once they finalize their review and determine the fiscal impact. These moves are standard in state tax administration. They are consistent with states accounting for situations unique to them and their residents, making sure that implementation happens smoothly. They are done to make sure that taxpayers and the governments alike have some measure of certainty. This resolution of disapproval will do just the opposite. It would cause significant uncertainty and chaos. Not for the federal government. This resolution would have no effect on the federal government or federal operations. The chaos would all be placed on D.C. This resolution would literally change the rules in the middle of the game while taxpayers have already started filing returns. It would require revising tax forms and systems and could force taxpayers to refile returns. It would create confusion for families, businesses, and tax professionals. The chaos would result in a revenue loss of $600 million over the next 4 years. Because D.C.'s law funds the district child tax credit and enhancements to D.C.'s earned income tax credit, this resolution would hurt D.C.'s admirable and groundbreaking efforts to address child poverty and provide a boost to low-income residents. And the fallout would not only impact businesses in D.C., but also spread to businesses in surrounding states like mine. Adopting this resolution of disapproval would make us agents of chaos, and we would be breaking decades of precedent to do it. Congress has rarely, if ever, overturned district laws through disapproval resolutions, and Congress has never before reversed a district revenue-raising measure. Our action would be so rare and so chaotic that it will have a damaging effect on D.C.'s bond rating. Credit rating agencies have warned that congressional interference in local revenue decisions can weaken D.C.'s credit standing and increase borrowing costs. This goes against why we are here. We're not here to cause economic instability and hurt taxpayers. We're here to help. This isn't about party line or ideology. D.C.'s independent, nonpartisan chief financial officer has raised serious concerns about the instability that this would cause. D.C.'s business community strongly opposes the resolution. Hospital, realtors, builders, hotels, and major employers aren't making ideological calls, but pleas for certainty. And every other state represented here, red and blue, including those which went further in their own tax determinations, would be watching us set a new precedent, the possibility of their informed judgment being overridden by unnecessary federal overreach, inviting chaos across their state lines. For these reasons, I urge all of my colleagues today to join me in voting against this resolution.